Good afternoon, everyone. Thank you for joining Weber Gallagher on our New Jersey Workers' Compensation team as we bring you our latest webinar addressing the COVID pandemic issues. And specifically, we're going to be addressing the September 14th bill that was signed into law by Governor Murphy. My name is Jeff Newby, and I'm joined today by my partners Mark Totaro, Jennifer Laver, and Penelope Camano. So our talk today is interactive, so please feel free to use the chat bar during the course of our discussions so you can propose any of the questions that you have. We're going to try and answer all of your questions during this session today with time permitting. If for some reason we can't get to your question today, we will get to your question and we'll reach out to you directly. All right, before we get into the new law though, I do want to discuss some of the science that has developed since this pandemic hit us in February, March of 2020, because as you know, the science continues to evolve. We find out more and more about this virus all the time. And I think it's good for all of you to keep your eye on the ball, I guess, know what's going on from a basic standpoint, and as in-depth as you can get, so that we can continue to, be educated about the issues that we're dealing with. So the first thing is, we know this was COVID-19 was coined in February 2020. So the virus is thought to spread through the respiratory droplets produced when an infected person either sneezes, talks, or coughs. And these droplets can land in the vicinity of other people, and that's why we have those 6-foot markers everywhere you go in the store or any kind of a bank, etc. So what are the symptoms? As you know, what makes this virus so unique from any other virus that has previously been foisted upon us is that some people have no symptoms. That's become a huge problem because people have COVID-19, they don't know they have it, and they're spreading it to other people. Prior viruses, it was obvious when someone was suffering from SARS or Ebola, and they could be quarantined. This virus is not like those. Some of the common symptoms that we're aware of are their fever, body ache, dry cough, chills, headache, etc. But the more severe symptoms are the high fever and the severe cough and shortness of breath, things of that nature. So the next question is, how long until the symptoms appear? How long is the incubation period? We know it's somewhere between 3 to 14 days, and the typical is between 4 to 5. But what's interesting is that range of 3 to 14 means that some people will have this virus and they won't know it for maybe up to a week. Other people will have the virus and they'll know much more quickly. So you don't know when you have transferred it to another person, or you don't know whether or not that person actually gave it to you, or vice versa. And I have some cases like that right now where that's going to be an interesting argument based upon our contract tracing arguments, who actually had the virus first and who transferred it to whom. Some of the other issues that we're dealing with. So the CDC is learning more and more about COVID-19 all the time in terms of comorbidities. And without going through these in any great detail, what I thought was very interesting is the new #1 problematic comorbidity is actually obesity. I think initially we thought largely it was going to be pulmonary issues, people with asthma and et cetera, or lung disease. But frankly, it's turned out that obesity is the #1 cause for more severe reaction to developing the virus. I think I skipped over, the testing that we're talking about. Obviously there's viral testing is determining whether or not you have a current infection, and the antibody test is telling you if you had a past infection. So the question of how long will the symptoms last, that is the question that we'll be dealing with workers' compensation. As we know, some people have no symptoms at all and the virus passes. Other people have mild cases, the symptoms last for a week or two. But statistically, 1/3 of all adults don't return to normal within 2 to 3 weeks. So it certainly is lasting more than 2 to 3 weeks in many adults. And severe cases, as we know, can last 6 weeks or more. So we thought there was a weather factor, that maybe there would be a decrease in infections during the summer months that would kill the virus. And we don't know whether or not that's going to be true until we start to get into these colder months. And scientists think that there's going to be an increase in the transmission in colder weather. And obviously that also makes more sense because there's going to be more people inside during the colder weather. We won't be outside as much as we had been before. It's good news to know that there are 26 COVID-19 vaccines currently in human trials, with 12 in phase 2 trials and 6 in phase 3 trials. And one more thing before we start the law, I thought this was very interesting. I listened to a webinar recently on this from scientists. And one thing that they pointed out that I had not thought of previously, and that is that, while everybody's thinking the vaccine is the be all and end all to returning to normal life, that may not necessarily be the case. So I was asking somebody this morning, I said, what's the vaccine that was developed for AIDS? And they kind of looked at me curiously, and they were thinking and thinking, and I said, there was never a vaccine developed for AIDS. There never has been. What we've developed is better medication for treating people that suffer from AIDS. That's why the spread of it and the death rate, et cetera, isn't really something that's talked about very much at all anymore, because the medicine to treat it has been so effective that the idea of vaccine being the be all and end all is not necessarily the case anymore. So that's good news. So if we can get medication to speed up, and this is maybe before the vaccine or in concert with the vaccine, it can really be a two-headed monster to kill it. So keep your eye on the ball in terms of the science that's coming out, so that you can compare your layperson knowledge to the cases that come across your desk, and make sure that they at least make some preliminary sense. Oh, and one other thing I thought was very interesting from the scientists this morning when I was listening to this podcast was that the viral part of it, that's the contagion, is when it's airborne. The contact of the virus with your hand on a railing, et cetera, that is much less likely to spread the disease. And the way the scientists explained it is, unless you contact the virus and it is still in liquid form, it is extremely unlikely that you would be infected. And the virus dries very quickly. So within hours, it's going to be dry. You'll no longer be touching the surface, a handrail or door handle, et cetera, that is liquid, in liquid form, that could transfer it to you. It dries on the outside and it dies when it does that. So again, keep that in mind. That is much more the airborne that is the problem, and not touching things. So now that we know a little bit about what's going on with the science, let's talk about the change in the law. And at this point, I'm going to pass the discussion on to my partner, Mark Citaro. So Mark, if you can tell us, what is it that happened on September 14, 2020, and what is the ramifications for our clients?
Thank you, Jeff. Before I get into what what the new law S2380 is all about, I think it deserves some sort of introduction, I guess, is why did we need this bill? Quite frankly, I don't think it was really necessary to implement some kind of legislation like this, because in New Jersey, I think we have built-in protections for workers who are injured or become ill as a result of workplace exposures. It is not unique that petitioners have filed claims like this and have proven their claims. This goes back to a decision involving Lyme disease cases. I don't know if you could switch to slide 6 there. Anyway, the Lyme disease cases that came out back in the late 90s found that workers that worked outside in infested areas that are known infested to be with ticks and contracted Lyme disease were found to be compensable. In regard to firefighters in particular, there was a case back in 2003, Lindquist versus Jersey City Fire Department, that also found that firemen who had emphysema and was, the allegation was exposed to smoke on a regular basis in the course of his employment, even though the person himself was a smoker, was able to establish that there was enough of an exposure there to prove that it was work-related. So it wasn't impossible that individuals now who contracted COVID were not going to be able to prove that it happened at work. Going on to the next slide, what came out in New Jersey as far as taking a first step in regard to first responders, it came out with the the Thomas P. Canzanella 21st Century Responders Act. That bill and that legislation was enacted last year. However, it was actually first introduced in 2014. Again, as a side note to that, this particular legislation has been used today as part of the pandemic. I have seen and heard of carriers that have considered the Canzella as applicable to the current situation for people who become exposed. But Canzanella was dealing mostly with public and first responders. It was intended for them. It was intended for firefighters. Mr. Canzanella was actually a fire chief who pushed this legislation. It came about as a result of concerns over exposure at 9/11 is where the concept first happened. And again, it was first introduced in 2014. And coincidentally, the state bar came down and not in favor of this legislation. Not that we weren't concerned about first responders and police and fire and so forth. But our feeling is that this was a carve out in our statute, that it was not necessary that these individuals who contract diseases or illnesses as a result of work exposures are certainly able to come to court and prove their case with the proper proofs. So in any case, the earlier legislation was vetoed by Governor Christie, and then it became law in July of 2019. And that was the history of Canzanella. Again, that law is similar to what we're talking about now, is because it created that presumption that first responders who are subjected to serious exposures from an emergency situation have a presumption that their condition is related to that exposure. It is a rebuttable presumption, similar to what we have now with S2380. But it was, again, the focus of that legislation was on the public sector, firefighters and first responders. Then we came along and we were faced with the current pandemic that we're involved in. And that stirred, again, the interest of creating this presumption that we're now talking about today. And that was S2380. It was actually first introduced in the legislature in May of 2020. And I'll get into an earlier version of the bill that was actually drafted, but Governor Murphy, after it finally passed both houses of the legislature on July 30th, Governor Murphy signed the bill into law on September 14th. Now, under normal circumstances, a bill that's introduced and approved by the legislature has to be acted on in 45 days. And if you'll do the math, this was actually the 45th day. But what happened was, because the bill originated in the Senate, and the Senate was not in session at that time, the governor actually had until September 24th to sign the bill or do something with it. Otherwise, it would have automatically became law. But in any case, he did decide finally to sign the bill into law on September 14th. What it does is it creates this presumption of compensability for what is now known as essential workers, essential employees. What the bill did was it expanded the scope of the Canzanella Act in defining what is an essential employee. It covered employees in both the public and private sector, and quite extensively. The bill was introduced, and the law says that this is retroactive to March 9th. The reason why that is the date is because that is the date that Governor Murphy declared the current health emergency that we are in. The bill is designed and states that this will remain in effect as long as the health emergency is extended, and it has been extended to the current time. So this law, in essence, is in effect and will remain in effect while we are in this pandemic and while the state of emergency is being declared. Once the state of emergency is over, or the governor says it's no longer extended, then the law is no longer applicable. What it does is it, again, creates a presumption, a prima facie case. If some essential worker contracts COVID-19, it's presumed that it is work-related. We'll get into later on what that does as far as litigation is concerned. We'll talk about, I think, the fact that just because the law says it's presumed to be work-related, that doesn't mean an employer automatically has to pick up this claim. But what it does is shift the burden of proof to the employer to say, no, this was not contracted in the workplace. There was no, perhaps there was no exposure. There was no one else in the workplace has contracted this, or this individual didn't come in contact with any other individual in the workplace with the disease. So that would be, one of the defenses. But again, it becomes the burden is shifted to the employer that must establish by the preponderance of the evidence that it's not related to any kind of work exposure. The preponderance of evidence standard is a reasonable standard. And as I pointed out before, the original draft of this legislation that came down actually in March, within weeks after the pandemic started, it had a standard called clear and convincing, which is almost an impossible standard for an employer to say that it wasn't related to a work exposure. But that was never introduced. It was only a draft. And I think the legislature finally, caved into some pressure to say that, we have to make this a more reasonable standard. And again, it applies to whoever is considered an essential employee. Now, if we go to the next slide, we'll talk about who is the essential employees. And as you can see, the legislation is quite clear. It covers, what I break down is between public, private, and public/private, because several employers overlap in that way. Clearly, it was intended to be for the police, the fire, first responders, anyone involved in the public sector that has to address any kind of public emergency like this. Clearly, that was I think the initial concern here with the pandemic. But then we got into what is considered essential services. And that's where we get into more of the private sector. And as you can see, essential services has to do with anything where it involves the public health, safety, and welfare. So this includes transportation services, hotel and other residential services, financial services, banking, and so forth. And anything in the production, preparation, storage, sale, or distribution of goods, which can again include food, beverages, medicine, fuel. So as you can see, this is a wide range of employees that this can cover. And then the last column I have here is the public-private. Again, I think this is more of what I think the legislation was mostly concerned about, is the medical and health workers and people who work in a health facility who have direct contact with people who have been infected with the disease. Clearly, those individuals are intended and are included. And again, they cross the line between public and private employees. The next slide just gives you an example of several jobs that this can cover. It's pretty exhaustive. I think an argument can be made for many of these employees who fit into these categories that they provide essential services and can be covered by the law. what an employer can do about this if they again have someone who declares that I have the disease, I think it's work related, I want workers' compensation benefits. We'll get into what we can do as employers and defense counsel in defending such claims. And leading off with that will be Jennifer Laver of our office.
You know what, Mark, before we go on to Jen, before we go on to you, there was a good question from somebody in the audience. And let me see, I'll keep this with Mark, but I may, ask both Jen and Penelope to interject their answers as well. The question is, when we do get a vaccine, can employers require the employee to take the vaccine? I know what my answer is, and Mark, I'm curious what your answer is.
I don't think you could force anyone for any medical treatment. So the vaccine would be a simple answer, no, in my opinion.
It's my answer as well. Penelope and Jen?
I think that aside from that, you have to be careful. Even if you were allowed to, we don't know the possible effects of the vaccine. And then let's say you did encourage your employees to do this and they did it voluntarily and they suffer side effects, which we don't know what they would be, then you would be responsible, I believe, for helping them take care of those side effects medically.
Yeah, I agree. You can't force someone to take the vaccine. There are, as Penelope said, it's not right now. We don't even know what's going to happen, but there's a medical dispute as to whether the vaccine, when it comes out, how safe it is, things like that, that you can't force anyone to take a vaccine. But there are other protections that you can require of them. So keep that in mind. The other protections that the CDC has talked about, those you can require your employees to be responsible for. So,
okay. In listening to, before I pass it on to you, Jen, just for the investigation part of this, in listening to some of these discussions about the vaccines, one of the scientists said we're not going to be able to support a vaccine until there are almost no side effects, because some of the side effects could be worse than the vaccine itself. And I think that could be a problem. Could you imagine the lawsuit for direct employer liability potentially for forcing somebody to take the vaccine and then they develop an infection, a spinal cord issue, et cetera, because they were told they had to take the vaccine. So that could be a problem. And so I think we're all in agreement regarding that. So Mark, thanks for taking us through the bill, and I apologize for the sliding issue we're having, but I have two screens and it's not clear which one's moving the slides forward. But so thanks for taking us through the presumptions, Mark, because the way I look at this is almost like a tennis match, and the law has allowed the petitioner, if they meet the essential employee definition, to basically get their first serve in. So their first serve, it's a bullet and it's over the net and it's in the square, and we have to hit it back, but we're permitted to hit it back. It's not like we got to stand there with a racket by our side and just let it go by and it's an ace. So we're allowed to defend these cases. It's just that if they meet this burden of essential employee, they have met, it's presumed that the COVID was contracted at work. So Jen, if you could take us through some of the investigation that you're recommending to your clients.
right. So as you and Mark had indicated, the burden shifts to the employer. You can rebut this entitlement to benefits and to treatment. You have to show that the worker was not exposed to or did not contract the disease in the workplace. So it's a preponderance of the evidence. So you have to show that it's more probable than not. But keep in mind that because COVID is so new, it's sort of yet to be determined exactly how and what type of defenses may work. So it's not a clear cut, this is what you have to show. There's a multitude of different things that you could potentially go through to defend that. And I know we're going to get into some examples later on. But the one thing I also wanted to point is keep in mind that if you were analyzing some of your cases before under the first responder statute, there's a big difference between that statute and this bill. Specifically, that the first responder statute dealt with those responding to and directly involved and in contact with the public during the incident. This bill doesn't actually require that public involvement. So you have the co-employee type of situations. So you need to keep that in mind, that coworker exposure under this bill would potentially be covered, unlike in comparison with the first responder bill, because there they had to be directly involved and in contact with the public. With this one, just because you have a positive COVID test doesn't necessarily mean that the employer should automatically accept the claim. You have the rebuttable presumption, and it's something that you really want to investigate. What you want to do is keep in mind you have 30 days to make a determination on compensability. You want to do the employer and potentially, obviously, you would want to notify your carrier and do the initial investigation pre-litigation. You would want to get a statement if the injured employee is capable of giving a statement, get it from them directly. If not, if there's a family member that's with them, should they be incapacitated, you want to try and get in as much information as you can from them. You want to talk to their supervisors, see who else would be able to advise you as to what the injured employee was doing surrounding this time, how many days they were working, if they had any other employment. Try and do contact tracing, get HIPAA so you can get their medical records, because a lot of this, even if it is something you ultimately accept, the medical information is another component that is something that you're going to have to deal with. You want to investigate other sources of employment. So there's the possibility you can accept a claim without prejudice if the investigation is taking too long, or in the situation where there's multiple employers, you may want to pay, if there's 2 employers and you're not able to get the information on the other employment, you may want to pay only half the claim and pay that without prejudice again. So keeping in mind that there's times where you don't want to formally accept, but you may want to provide at least indemnity and or medical in a limited basis. You want to get an ISO report. You also want to review the personnel file to see if there's who their PCP is, if there's any pre-existing medical conditions that could potentially impact you with regard to medical treatment. So it's really important that you try and get that medical baseline and get whatever information you can on those issues. So Penelope is going to now talk about the examples as to potentially how you can rebut the presumption, and then she's going to go on and talk about some of the claims that we've been seeing coming in.
So what does preponderance of evidence mean? This is all very new to us, and it's going to be case by case, very fact sensitive. So it's not a broad brush that you can apply to all cases, because, just because this law has passed doesn't mean that you're going to be accepting all those claims or even revisiting the claims that you have already denied. For example, in my estimation, when you get the answers to interrogatories or answers to questionnaires, and you see that they live with other people, spouses, children, siblings, and so forth. Let's say your employee is a nurse, but yet her husband is a worker in an Amazon warehouse, and the son is potentially a police officer. Then what? I think that starts to build the preponderance of evidence, and that needs to be flushed out thoroughly. So that's why this information that we need to get immediately is so important. Another example that I have with one of the hospitals I represent is an EMT dispatcher. Now, an EMT dispatcher is not the same, in my opinion, as an EMT. For example, I don't know, and we don't know, is he working in an office by himself? Is he being exposed to other employees that potentially have it? So these are the questions that we have to raise and we have to investigate. And this, I believe, bit by bit, will start building the preponderance of evidence. So again, this information that we do now in the investigation is vital to establishing that defense. Again, ask them for a list of providers, as well as the PCP records that Jennifer mentioned, because people can be treating for a multitude of conditions previously, and you won't know that, and perhaps the PCP records may not capture that. So, you need to really take a look at what other types of exposures they may have. I don't believe that going to the supermarket or going to the gas station is going to build that preponderance of evidence, okay? It has to be something that's unique to their situation, their living environment, people they have seen, they're intimately related with. And then you would have to go further and see who tested positive first. Was it the husband? Was it the son? Who manifested symptoms first, and so forth. Another thing that we've discussed previously is concurrent employment. And sometimes we have people who work two different types of the same job in two different locations. Again, attendance records. You have to look at where they were working immediately, but I would say the 10 to 14 days immediately prior to their symptomology. If they hadn't been working for you for a couple of weeks, you may not be on the hook. But again, these are all things to consider. We're making these determinations as they come in. You may not get this information right on at first when you first investigate the claim, but hopefully throughout the process, and then when it becomes litigated, which unfortunately a lot of them will be litigated, we'll be able to help you in obtaining this information. I'm going to jump forward to the next slide when we're talking about the types of cases that we're seeing. At this point, all the cases that we're seeing are occupational in nature. Even if counsel has on occasion filed traumatic COVID cases, we are treating them as occupational and providing them with our COVID specific interrogatories that we prepared, and you'll see later on in the presentation. But at this point in time, I'm seeing occupational pulmonary cases, occupational cardiac cases, occupational psychiatric claims, occupational gastrointestinal claims, kidney claims, and then of course the dependency claims. The thing with occupational cases is really what is that the medical science determines the outcome of the case. This goes into the occupational pulmonary cases that Mark had discussed before with Fiore. And the thing is that at present, we do not have sufficient medical evidence or scientific evidence. We're still learning. The experts really don't know the full effects of COVID and how it will affect the body. So without this, it's very difficult to determine what is and what is not related to the COVID-19 virus. For example, with occupational cardiac cases, I see people who are suffering from tachycardia and maybe even just heart palpitations. Heart palpitations by itself are not a diagnosis. It's just something that's going on in your body. And unless they can quantify or qualify what it is that's happening to your heart, it's really hard to causally relate. However, we do know from the scientific medicine and the scientific articles that have been presented that the COVID can affect, can weaken the muscle of your heart. So maybe now you don't have side effects, but what about 2 and 3 years down the road? This is where we're going to have to be careful, because there may be latency issues in the future that we may have to reconsider. If there's any changes, if they have an echocardiogram and they had a prior echocardiogram during a physical, and now the echocardiogram shows that there's some changes, but not a disease, what happens to your case? Will we have to do medical monitoring in case in the future they develop some condition that could possibly be related to COVID? This is not presently what's going on, but these are things that we need to keep in the back of our minds, because that's going to develop. As we've seen with other types of occupational cases like asbestosis cases, things happen years from now, and what has happened is the legislature then relates it back to the exposure. So we have to keep this in mind. On occupational psychiatric cases, what I am seeing are 2 types of psych cases. People that had the virus and are afraid to go back to work, and that they will contract it again. I have several cases where people are very hesitant to go back to work, and they remain out of work, and they expect us to pay temporary disability benefits, which we are definitely resisting at this time. Because a lot of people are not getting medical treatment. They're not getting psychological treatment or medication for these conditions and just indicating that they are afraid. And I just do not feel that we should be paying for those types of claims. The second type of occupational psychiatric claim I'm seeing is the stress disorder from the death of a co-employee. And that, unless they're in the zone of the person who died from the COVID, I also don't think it would be related. You need to know who the coworkers were you need to know who were those coworkers that died, and did they work directly with them? You just can't know of someone dying in the hospital or in the company and then claim post-traumatic stress. They have to be in the direct zone. And also, a lot of people are dying because of the COVID-19, family members, friends. So it's not necessarily as a result of a co-employee dying, perhaps, that they're suffering this trauma. So these are all things that we have to flush out. And out of all these claims, these occupational claims, the psychiatric claims are the ones I really feel that we should not accept unless there are extenuating circumstances. I mean, we're going to try to Section 20 all these cases if we can. Some may not be possible because of the side effects people are having, and if we find later on that they're causally related. But on occupational psychiatric claims, we really need to resist them as much as possible and try to resolve them via Section 20 claims. Let me see. I'm also seeing cases where, yes, perhaps we can admit that they did contract COVID through the workplace. Maybe they had pneumonia. Maybe we're paying them for up to a certain point. But then we have cases where people have already gone through this, and now 2 months into or 6 weeks into this, they're developing additional sequelae, gastrointestinal issues, reflux, diarrhea, soft stool, indigestion, or people with like the heart palpitations. Now, they're all done with the pulmonary aspect of the COVID. So now the people are still being held out of work. Some doctors may say, oh, it could be COVID related. Some doctors are not commenting. And this is where I see where the cases are going to be much more complicated, because I really feel that it's going to be tough for these doctors who don't have sufficient medicine at this time to provide reports to us or counsel to say that it's related to the COVID. People are going to attempt to relate it to the COVID, but if a person has a pre-existing history, how do we know that the COVID aggravated it? Or, I mean, it's easy when a person never had any of these problems and then all of a sudden has them within a time frame that they developed the COVID. Yeah, that would be more clear cut. But with people that had this condition pre-existing and have been treating regularly several times a year for it, I'm not necessarily going to jump on board with that unless I have a doctor of my choosing comment on the causal relationship. I'm also seeing cases where an employee perhaps participated in a trial where they took that medication, the, what's it called, the hydroquinone, where if you look up hydroquinone, that medication can cause the type of side effects, cardiac side effects, cardiointestinal side effects that potentially employees are complaining of. Now, if the employer didn't force you to do this trial and you're doing it, now, am I responsible for paying for that? I don't know. These are all the questions that we need to flush out. I venture to say with the more complicated sequelae and like the more complicated it is with the gastrointestinal and the cardiac, we need to fight on these cases because you don't want to get on the hook for a lifetime of cardiac issues, which will most likely happen. So dependency claims. A number of people have died, and you are potentially picking up dependency benefits for your employees. However, there are situations where a person worked for multiple employers and perhaps another employer has picked up the dependency benefits, but between your employment, let me backtrack. Their payments, what they're paying them, the rate they're paying them may not be the petitioner's full rate, the employee's full rate. In fact, if this was presented to the court, the judge would want us to bring the person up to their full rate. So you may want to pay, as the employer who hasn't picked up the dependency claim at this point, you may want to pay the difference between what that first employer is paying and the max rate, not necessarily your full rate. Jen, do you want to interject there about this?
Well, yeah, so the part of the hand and foot bill, if those of you will remember that recently, the hand and foot bill just recently came about where it was changing the rates. As part of that, it also changed the dependency benefits. And there's a little bit of an issue with regard to the bill and how it changes the statute. But generally, the dependency benefits, keep in mind, they had been at $3,500. Now they're at $5,000. So keep in mind that there is a change in that, and it's now the $5,000. The other thing I wanted to point out, Penelope, is that with regard to these claims, some of the claims that I've seen come in are being pled as a specific accident. We are always treating it, even if they put a specific date, because the exact date of exposure with COVID is so difficult for anyone to pinpoint, because no one knows exactly how they got it or when they got it, that because of that, all claims should be treated as an occupational. So even if a CP is filed, claim petition is filed, and it lists a specific date and doesn't check that it's an occupational claim, you want to treat it as an occupational claim. Our office will send out occupational interrogatories, specific COVID interrogatories. So, you know, why the reason we have it all listed as occupational is because that's how the claim should be treated, and that's how the claim should be analyzed, because that's exactly what it is, because no one knows exactly, you know, what date they had this specific exposure. So, you know, keep that in mind.
And the truth of the matter is, by us responding as an occupational claim, we have much more ability to conduct discovery on these claims than we would with a traumatic admission. So denial. So again, with all these cases, investigation is key. The sooner you start this process, which would be when they first come to you on a medical only claim, advising that they believe they contracted COVID on the premises, start there and then go forward. In fact, the next slide that we have are the questions that employers and adjusters should be asking of the employees. Originally, these questions came from, we put together for questionnaire purposes when the first influx of medical only claims occurred when the COVID pandemic started. But we've taken these questions and fine-tuned them and formulated them into very COVID specific interrogatories, which we serve along with regular occupational disease interrogatories to be answered. There are many questions that we have put together that are part of this PowerPoint. And if you write to any of us after the presentation, we will send this to you so that you have it. You could use these questions either as questionnaires, or you can use them, or they can be used for interrogatory purposes. I'm just going to point, I think, what's the last question? Can you guys take us to the last question?
Last question from the audience, Penelope?
No, the last question on the questions on the interrogatories, the questions that we've done.
Yeah, can you see number 16 there?
Oh, okay. I was going to talk about, we had talked about this, the four of us last night, that one of the questions that we're going to be including in amending this is to include that if ask the employee if they have received any money through the CARES Act, because that would be double dipping. So if you received money through the CARES Act, then you would not be entitled to workers' comp benefits, because that would be considered double dipping. We will be adding this question to these interrogatories, and when you request this information from us after the hearing, after the seminar, we will forward it to you.
So I have a few things I wanted to comment on what Jen and Penelope have been talking about. One, that was a question that we got even pre-seminar, was the interplay between the CARES Act and the Workers' Compensation Act, COVID-19, and this new bill. And as you probably know, the CARES Act is for non-work related benefits. The idea of the CARES Act was to provide benefits to injured workers during this kind of gray area if they were laid off or couldn't get to work for whatever reason, whether or not it was quarantine, et cetera. So the CARES Act was to provide them with the unemployment benefits, with the $600 additional check, et cetera. If somebody gets those type of benefits and at the same time is requesting workers' compensation benefits, as Penelope pointed out, there'll be a dollar for dollar offset and credit. So you're not going to have to pay for the same week of wage loss twice. So that was one of the questions we had. And since you guys have been talking, we had a few more questions pop up. And Tom, you had asked about permanency. We're going to get to that in just a couple slides before we finish today, about the effect these COVID claims may have on permanency awards. But one of the questions that was posed was, if an injured worker comes to us and says that they had COVID, but they had it back in April and there was no testing available. First of all, the question, how are they going to be able to prove that if there was no testing available? If they said, I have X, Y, and Z symptoms, I don't think that's going to be sufficient. And then the second part of that question, which was a good question, is if they test and they come back positive for the antibody test, would that be sufficient? So to kind of backdoor it. And Jen shaking her head no, and I agree with Jen. What's interesting is, again, listening to and reading more of the science, you can be positive for the antibody, but it could have been a different version of COVID. There are lots of viruses out there. COVID-19 is just one of them. So you could have the antibody, but it isn't necessarily related to COVID-19. So no, they can't backdoor it that way either.
Jeff, the other issue with that backdooring is if they try to backdoor it, what are they backdooring for? There is no lost time, you presume. They weren't sick. So what is there? There is no there.
Okay. Yeah, hopefully at this point they're making this allegation, but they're now hopefully healthy and recovered.
Yeah.
I have to go quickly because we don't have a whole lot of time. We have more topics to cover, but there was a few more questions. And I think it was a good question. One of the questioners, probably a healthcare provider, said, if we can insist upon the flu vaccine for our healthcare employees, why can't we insist upon the COVID vaccination? And I think it's something to look into. And that would probably be specific to that industry, the healthcare industry, because you want your employees healthy as they're dealing with members of the public who are bringing illness already to you to get cured, and they don't want to have it compounded with a COVID exposure. So we can look into it. It's more of an employment issue, though, not a workers' compensation issue. So it's a little bit different from workers' comp. And a last question, Mark, I'm going to ask you for your input on this last question that was asked. And the question is, because of what Penelope was talking about the long-term impact of some of these claims, where they could have, the kidney issues, and there can be latency periods. And you talked about medical monitoring, for instance, Penelope. The question that the person asked was, can carriers start to have larger and larger reserves to kind of protect themselves against, these future case spiraling out of control due to a latency period? And part and parcel of that, can it affect their rating? And I think the bill specifically, Mark, correct me if I'm not wrong, the bill specifically states that COVID claims are not going to affect ratings. So be happy about that.
Yeah, that's built right into the legislation. It's not, it's not reportable that way. But certainly the experience of numerous claims, I imagine, will have some impact on the cost and need to properly reserve files and claims.
Okay.
I'm certainly no expert on setting reserves, but I think just because it's out there, it's going to affect, the need to have proper reserves.
There's another question. Under the law, it states, and this person wants confirmation, that you cannot make an employee utilize paid time off to quarantine in case of exposure that is not work-related. I don't know that that's the law. I mean, if somebody was exposed and they're told that they need to stay home and quarantine, I don't know that maybe the CARES Act might cover that. Yeah, Jen, you're nodding. You think the CARES Act would cover that, maybe that period of 2 weeks?
Correct. Yeah. The only workers' comp only kicks in if you have a COVID positive test. So quarantining is not part of workers' comp. So keep in mind, you always, unless they show you that they have a positive COVID test, treat it as an employment claim. If they're to be paid under the CARES Act, if they've exhausted that time, then they have to use their paid time off. Unless and until they have a positive COVID test, do not consider workers' comp. So that's really one of the keys that you have to keep in mind, that, and similar with the antibody test, that's not indicative that they had COVID. That just shows that they have antibodies that may protect them from getting COVID. It doesn't mean that they actually had it. And the medicine supports that. So, you know, for those that were unable to get tested or didn't get tested, you know, it's a problem for them because they can't prove that they had COVID. So all of those claims, you should treat them as normal employment issues. But since we're short on time, I'm going to go on to the next issue, which we were talking about with the changes in law. What do you do? So if you've had claims come in and you've already reviewed them, I know I just had this discussions with one of my clients that my recommendation, and we all seem to agree at this point, is do nothing for the most part. You hopefully have already done the investigation. So if you haven't, you may want to go back and do the investigation now, but don't change your analysis of those cases that you've already potentially made a determination. So if you've determined that that this wasn't workers' comp and they were paid under the CARES Act, don't now go back and change it. If a claim petition is filed, or they come back to you and say, with this new law and this bill, what should happen, then you would need to reevaluate it. But for many of you, you've already reviewed so many claims that to go back and review every single one, it's just unrealistic. It's those that either file a claim petition that you now have a change based upon the bill that you want to reanalyze, or for those that you didn't do the investigation initially, you really should go back and do all the investigation. It doesn't necessarily mean that you should change if you told them that it was denied based upon the case law at the time. Don't necessarily go back and change that view, but you want to, at this point, try and get all the information you can with regard to the claim. So keep that in mind. But you know, I wouldn't recommend raising a red flag to an employee about potentially filing a claim by going back and changing whether if it was denied, changing it to being an accepted claim.
And I think we need to deal with them differently. And tell me if I'm wrong, Jen, pre and post litigation. If they haven't
Correct.
and they haven't filed a claim, that's one thing. But if they filed a claim, and I have one now where we had denied it, and this bill passed, and I think the petitioner will qualify as an essential employee, I think we need to revisit it. Doesn't mean we're accepting it's invincible, but rolling up our sleeves and doing the investigation that we've discussed.
And one of the things to keep in mind is the employees. So you may have claims. I have a claim petition that was filed, and the employee, when we analyzed it initially under the bill, they weren't considered. So a truck driver isn't one of those listed employees, so they wouldn't necessarily be covered under it. And so that even if they got it from a co-employee, they're not necessarily covered under the bill. But you might want to keep in mind as to what those people are. So if they deliver to a supermarket, or if they deliver to the post office, the court could potentially give them that extension and grant them the presumption that the bill does, depending upon where they're delivering. So, you know, once a claim petition is filed, you want to analyze it. All the claims that we have going in, we've now reanalyzed based upon the bill and how it may impact you. But anytime you have a new claim come in, you want to analyze it differently.
Yeah, and a questioner asked, or one of our attendees asked, you know, did we go back and review all claims denied since March 9th? And I think the answer to the question I think we're answering there is no. If we're in litigation, we need to. But if we're not in litigation, they may have fully recovered. Leave it alone unless they come back to you and they're still out, they're still disabled, then we'll look at it again. If we're in litigation, we're going to have to. They have counsel and there's going to be upcoming hearings. You see a question about whether or not they anticipate any challenges or additional litigation to try and repeal this law. Mark, before we finish our last couple slides, do you think there'll be a challenge to this COVID bill?
I don't think so. I mean, there may be a political challenge, maybe by a different party that enacted this legislation, but I don't really see anything like that happening. It is really a temporary law in effect. It's only in effect during this time of a health emergency. So It's going to go away, hopefully, sooner than later, once we get control over the situation. So I don't foresee that happening right now.
All right, Penelope, you want to say something?
Yeah, do you want me to go on to the next slide, Jeff? Can I talk about it?
Well,
Which-
we have 4 minutes. So what I wanted to do is, and if you want to jump in, we'll start with the last issue about these benefits available. But I just want to mention before you begin that, just to tell everybody, this is constantly evolving. This is brand new. So who's going to be covered and who's not going to be covered? And your questions are great questions, but we don't know all the answers yet because this is just developing. Whether or not we can even propound these interrogatories, I think we're going to be able to. I think the judge is going to give us leeway in discovery because this is also new, and it's our burden to defeat a case with a presumption. So I think the judge is going to give us a lot of leeway for discovery. So Penelope, can you take us through? Let's say they have the presumption. Are they entitled to, let's say, these first 2 benefits, temporary and medical?
If they meet the presumption, is that what you're saying to me?
Yeah, let's say they meet the presumption. Mm-hmm.
Oh, yes, they would be entitled to temporary disability benefits, medical benefits, permanent disability benefits, like a regular workers' compensation claim. They'd be entitled to all the benefits noted on that slide.
If they can prove it.
If they could prove it. I think the issue here is we have to be practical people. We don't want to create bad law. I know everyone wants to challenge these cases, but there's not enough evidence at this point that I don't want anybody to start trying these cases where a judge can issue a law that will affect all of us later on. If you can try to resolve these cases, pay some benefits without prejudice, small Section 20 settlements, I would encourage it. Even if you cannot Section 20 all the allegations, I would try to be creative and try to Section 20 as much as you can. For example, if they're not really having any pulmonary issues other than the COVID, a small Section 20 might want to keep that cardiac aspect open depending on the testing and if they can show that there's been a deterioration in the heart muscle. You have to be creative. You have to be practical. Right now, when we go to court, the judges are going to be very sympathetic with the petitioners. Yes, they are going to allow us, I believe, greater leeway in defending the litigated claims. Jeff had brought to our attention the fact that we could do discovery testimony and file motions to do that, especially if we believe that the petitioners being less than forthwith with the information they're providing. We can file motions with the court to get discovery testimony. Jeff has done this on other cases, and I think it's a very good mechanism to use on these litigated claims if you feel you're not getting cooperation from your adversary or the petitioner. We could take testimony and ask them these questions, and they are under oath before the court. And I want you all to keep that in mind on the litigated claims that you may be seeing coming into your offices. And I think that's it.
So, and way at the beginning, my buddy Tom asked, what about permanency? And I think this is very similar to occupational disease claims. If they can meet all the burden of proof, they have the presumption, they've got the medical evidence, they've got the fact evidence that they were exposed at work, they developed the virus, and they received temporary medical benefits. If they can prove that they have a permanent residual loss of function due to the virus, they would potentially be entitled to a permanency award. What we're going to be arguing, and hope we're successful in arguing, is that they have fully recovered and we can get a Section 20. And I think the vast majority of the cases we will Section 20. Yeah, Penelope.
One more thing with regard to what you're saying, that's why it's really important to get a medical baseline, because if they have prior testing and diagnostic testing, x-rays, pulmonary x-rays, EKGs and so forth, if you let them treat on their own without getting control of the case, even without prejudice, you run the risk of them being able to prove permanency versus you getting control of the case, maybe having them tested a year down the road, an x-ray to the chest, maybe the markings on their lungs or the donut-sized holes that may have developed because of the COVID have regenerated. We don't know. So it's important, even if you do so without prejudice, to get control of the medical on people who have lingering side effects. And
that's really important because of the fact that the one of the things, like Penelope had said, that's really important because of the fact that with this COVID specifically, the people who have really the worst outcomes are those that have significant pre-existing. So you're not having someone, for the most part, a healthy individual with no pre-existing is going to have these really, really, really bad side effects from getting COVID. So it's getting the information that you can to be able to support that there's no change in their condition. So while they had COVID, you know, or getting them back to baseline. So that's one of the things that, you know, you really need to investigate the pre-existing medical, which is different from a lot of the claims that we have. Normally, we're not allowed to get as much medical with this because there's so many unknowns. The amount of medical that we're going to be entitled to based upon the condition, it's going to be more significant than normal. So getting those HIPAAs out, if it's pre-litigation, as soon as you're notified, having them sign releases, getting you the information is really important.
Okay, I think we're just about done. Just wanted to say, I think we're going to get more discovery in these cases than we've ever gotten before. The judges understand what pressure this is going to put on employers financially, and I think they're going to let us get a lot of discovery, knowing that, you know, the burden of proof is more on us. So thank you, ladies and gentlemen, for joining us. When you sign off, you're going to be brought directly to a survey. Please spend a couple minutes on the survey and let us know what you think. And anyway, good luck with these claims. Please feel free to follow up with any one of us or anybody else in our department or the firm regarding your questions. Thank you, everybody. Have a great afternoon.
Thank
Good
you.
luck, everybody.